Hello friends, in the series on the income tax cases, today we will discuss the case of Principal Commissioner of Income Tax versus Durgapur Projects Limited. This case has been reported in 454 ITR at page number 367. The matter has been decided by Calcutta High Court and the date of the judgment is 24th February 2023. In this important judgment, the focal point of litigation was that whether in case of compulsory acquisition of land or building or both by the government or under any scheme of government for the projects of the government like developing highways, whether section 50C will be applicable on those acquisition of land and building by the government. In this case, the Assessee land and building was acquired by National Highway Authority of India. The compensation determined was below the market rate. The assessing officer applied the stamp duty valuation rate and taxed the income of the assessee accordingly. Before proceeding further, it is necessary to discuss that what was the purpose of section 50C. Section 50C broadly says that when the land and building is sold and the sale consideration is less than the stamp duty valuation which is fixed by the municipal authority, then in that case the stamp duty valuation will be considered as the sale consideration. The important point to note in this case is that when the property, that is land or building, is compulsory acquired by the government, then in those cases the stamp duty is not paid by the government. So when the stamp duty is not paid by the government, whether it can be said that whether section 50C, which talks about the stamp duty valuation, will be applicable or not. It is also important to know in this matter is that in case of compulsory acquisition, the two important acts, that is Transfer of Property Act 1882 and the Indian Registration Act 1908, does not apply. The court said that when the stamp duty is not to be paid, when there is no importance of stamp duty in this case, when the Stamp Duty Act will not be applicable, then the value adopted for the stamp duty valuation cannot be adopted for calculating the sale consideration in case of compulsory acquisition. And the third point was that the objective of section 50C was to curb the black money. When the land and building of the assessee is not sold by the sweet will of the assessee and it is compulsory acquired by an agency, then it cannot be said that the assessee is involved in some practice which is in accepting the money in cash or in some other form. So whatever the value has been determined by the authority is the final value, and that cannot be compared with the stamp duty valuation for considering or for determining the sale consideration of the assessee. The court also pointed out about the Central Board of Direct Tax circular number 36, which was brought in 2016, which says that the Right to Fair Compensation Act 2013 says that when the compensation is paid to the assessee for acquisition of compulsory property, then in that case the income tax will not be leviable on the assessee. And even if the income tax department does not give the specific exemption in case of compulsory acquisition, then in that case also the exemption will be available to the assessee for the compulsory acquisition of land and building. Friends, this case is very important because this will be applicable for all those acquisitions which is compulsory acquired by the government, by the various authorities. So in that case, the sale consideration, the compensation which the assessee is getting will be the final price, and the stamp duty valuation will not come into the picture. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Durgapur Projects Limited, and this case has been reported in 454 ITR at page number 367. The matter has been decided by Calcutta High Court and the date of the judgment is 24th February 2023. Thank you, friends.